Alex here with another video on high conflict child custody. This video is going to be on restraining orders. In Nevada, the formal name of at least the restraining order most people are talking about is an order that keeps their ex away from them. In Nevada, this is actually not even called a restraining order. It's called a protective order. So what these are supposed to be used when you have a situation where you're with a boyfriend or a girlfriend or a wife or a husband, or even, I believe, family members are included. I'm not sure on that. And there's some kind of domestic violence situation. What you can do, and what happens, and it happened in my case, my ex filed one against me. What you can do is go to the court and obtain something called a temporary protective order. This is done ex parte, which means that the adverse party, the person who's being targeted with the protective order, does not have an opportunity to give their side of the story initially. So your ex goes, we're just going to do it in this context because this is how it worked for me, because I was the adverse party and she was the petitioner. My ex went to court, and this is the process. You go to the courthouse and you file for a temporary protective order, and you'll get a hearing either on the same day or the next day. I think usually it's the next day. She went in. I'm not allowed to appear at that first one. I don't even know what's going on at that time. She goes in. She explains to the court why she feels her life is in danger, or there's a potential for her life being in danger. And then based on her testimony, and her testimony alone, the court will enter the temporary protective order. That is then served on you. Once that protective order is served on you, you have to abide by its requirements. Only until the date of your hearing. So when the judge enters the temporary protective order, at the same time the judge will set a hearing on the extended protective order, and this is the one where you have an opportunity to appear and testify and defend yourself. The disappointing thing about this, and this really does fluctuate, it seems to me like sometimes the judges are in this better safe than sorry mode, and they tend to grant them all. And other times, the judges really want evidence, and they tend to deny them all. And I'm not sure if it's based on the news cycle or whatever kind of harm recently happened in that locality, or if it's just a random trend between different judges. But I'm going to let you know that at least in Nevada, the standard is certainly not in your favor if you're the adverse party. Your ex doesn't even have to show that you've actually done anything, because all they have to do, they can't show that. That's even better. The judges like that, because that's great. That's proof that you've actually caused them harm. But they don't even have to show that. All they have to show is that there's a possibility or a threat of domestic violence happening in the future. And to defend against that standard, it's almost impossible. All they have to do really is show that there's some crazy dispute going on in the text messages, or even just allege it. And especially if there's been police reports, and the court's going to say there's a threat for domestic violence, and I'm going to grant the order. And it really sucks because it makes it look like you've actually done abusive things. And if they have an attorney, this is something that comes up a lot. If they have an attorney, they will use it to say, look, this person has a protective order against their ex. They're not going to say, Your Honor, there's a threat. They're going to say, Your Honor, they have a protective order against him. They've abused them. And so, that puts you in the position where you have to explain the law to the court, and it doesn't always go well. And this is one of the things that's brought up in a lot of other videos on divorce and child custody, is people using protective orders to give them an advantage in their divorce or child custody matter. In other words, they don't even really feel that they're in danger. They just want an advantage in their actual court case. So, as a side note, I'm going to say that if you're going to represent yourself in any kind of situation, the protective order hearing, I hate to say it, it's one of the situations where you may as well represent yourself, because even if you have an attorney, there's a good chance you're going to lose, because the other side doesn't really have to show you've done anything to them. So, if you're going to have to choose between spending your money in your divorce and child custody action and spending your money in the protective order hearing, because in Nevada they're two separate things, you may as well just represent yourself on that one. I represented myself. I lost. My ex was, I don't know if I'm going to say I lost, because my ex asked for a 1-year extended protective order, and I got the vibe that the judge didn't believe her, but she still wanted to be better safe than sorry and ordered a 3-month extended order. So it was not so much that I lost. It was, I mean, it was a favorable outcome because 3 months went by really quick. And anyway, the point is, once she had that protective order, she used it in the child custody case. Not as much as I thought she would have, probably because the judge in particular didn't seem too convinced, especially because of some of the other evidence that I presented to the court. But I imagine that in other person's situations, it might be leveraged a lot more. In my case, my ex used it to conceal her residence. And in another video, I think it's my first video, I talk about a Supreme Court publication. I'm just going to post a link down so that you can read all about it from the Supreme Court, because what she did was she used a protective order to conceal her residence, and that was through something called the Confidential Address Program, which is run by the Secretary of State of Nevada. And I was able to challenge that through the Supreme Court and change the law, at least the case law. So my advice to you is, if you genuinely feel that you're in danger, you can use the protective order, and it's an appropriate mechanism. It is still just a piece of paper, so you should take other steps to protect yourself. But I will say that it can backfire if you use the protective order in a way to gain an advantage in your divorce matter or your child custody matter. Just remember that my ex did this against me. She used the protective order. She said I was abusive, and in the end, the court terminated her parental rights, not mine. And that's just an example, an extreme example of how much something can really backfire. Because, I mean, in the end, that protective order led to the Supreme Court case that actually did cause a very long chain reaction. It was a years-long chain reaction that led to the outcome that is today. So again, use protective orders wisely if you need them. And just keep in mind they can be used against you later on. You could be portrayed as an ex who's, filing restraining orders or whatever to keep kids away, to keep my kids from me. I mean, this can happen. I'm not sure if lawyers have different advice on that, but my experience personally and from hearing other people's cases is that the fad of using the protective order as a tool is starting to really go out of style with the court, at least here in Nevada. It's just not, it's just not going to get you anywhere anymore. So use them appropriately. Don't abuse them. And with that, I'm going to end this video.